Tyler Summers is my favorite Boston family lawyer. He's an accomplished family law attorney with a boutique practice focused on prenuptial agreements, divorce, and child custody. He's gotten top honors from his peers and is known as a compassionate litigator and mediator. Tyler is active in a number of professional legal organizations and community nonprofits, and he's also developed a niche, consulting for members of the LGBTQ community who face unique issues in family law. And that's exactly what we're here to talk about today, your big gay divorce. Hello, Tyler, and welcome to the show.
Tracy, it's an honor to be with you today.
I know, I'm so excited to have you here today, and I'm so grateful that you're willing to have a candid conversation with me because sometimes some issues are a little harder to talk about and people don't want to touch them. But I thought that this was an interesting topic to talk about because marriage equality came on the scene. It made it so that gay men and women are afforded the same marriage and divorce process as heterosexual couples. And I think that that's good in many ways because I think ultimately laws are meant to ensure that if you get divorced, there's going to be an orderly and fair process and it's going to protect both parties, right?
Exactly. That's the goal. Whether we're there yet or not, we'll see.
Right. But the divorce process, let's be honest, wasn't set up for gay people. It was set up for heterosexual couples. And the vast majority of the divorce laws were created at a time when women were mostly not working outside the home. So how do you think that that impacts the divorce experience for gay men and women?
This is such an important topic, Tracy. I'm glad we're talking about it. When I like to think of LGBTQIA divorce, and I'm just going to say gay divorce for simplicity, I like to think about 2016 and post-2016. So 2016, Tracy, that's the year when the United States Supreme Court issued its landmark decision that legalized same-sex marriage throughout the United States. Prior to 2016, we had various states that did allow for same-sex marriage, but we still had many that prohibited it. That was a wild time for same-sex couples because one state may treat them differently than another state. And oftentimes that required and necessitated legal advice, whether or not you're divorcing or not, expert tax advice, expert accounting and financial advice. Much of that went away when the Supreme Court said, no, same-sex marriage will be uniform across the land. So frankly, slightly less work for people like me because now we have so much uniformity. But obviously something I very much support. I think you very much support. I think most people have gotten behind.
So do you think that the divorce laws as they stand today are really experienced in the same way by gays? Is there similar protection, or do you feel like, when, gays are getting divorced, they have special issues and the laws really aren't set up to address that properly?
Sure. So a common issue that we see in many relationships, but particularly same-sex relationships, is what we call premarital cohabitation. So let's say you're in a state that only legalized same-sex marriage in, say, 2016. But that couple resided together, held themselves out to the community as an item, as a married couple for, let's say, 10, 20 years prior to same-sex marriage being legal. So they get they get married in 2016. 5 years later, they're now divorcing. Is this a 5-year marriage, or is it really much longer, given that they were an economic unit, an economic partnership, and they cohabitated for years, if not decades? That's a question, at least here in Massachusetts. You're not bound by the date you signed your marriage certificate or the date you got divorced. Courts can look at premarital cohabitation, which can be key in these same-sex relationships.
Well, I think one of the really big issues that comes up with this cohabitation period is what happens with the assets that we bought during that cohabitation period. So maybe one spouse paid for a very large, expensive asset and they weren't married then. Does the other spouse have rights to it, even though it was purchased before the marriage? That's an interesting issue, right?
That is the issue. And ultimately, those types of issues need to be, at least here in Massachusetts, they need to go before a judge. We have no, at least here in Massachusetts, and I'm frankly not aware of any state that provides detailed statutes which provide guidance about how we're going to treat premarital cohabitation. Here in Massachusetts, had that economic partnership existed prior to the legal marriage for a long period of time, if I'm representing the spouse that didn't invest that huge chunk of money into that piece of real estate that you said in your example, I'd make the argument that contribution is really marital. These people were effectively married. They didn't have a
Right.
marriage certificate, but they were acting as a married couple.
Well, and if you are in a state which recognizes that spousal support is important, many times spousal support calculations have a component to them that includes how many years the couple was married, right? And so if they had a lengthy cohabitation period, that could work against the spouse who is needing to receive spousal support, right? And well, it could work against one or the other of them.
Absolutely. And I think that's where strong advocacy comes in. You're absolutely right. Many states have alimony statutes that provide for a duration of alimony post-divorce, and that duration is usually tied to the length of the marriage. The shorter the marriage, the shorter the duration of alimony. The longer the marriage, the longer alimony may be paid. Now, a strong advocate can take that law, present it to a judge, and make a strong argument about how that is not equitable, how, frankly, it could be even viewed as discriminatory. And at least here in Massachusetts, judges can deviate from the guidelines to account for a situation just like this.
What I like to tell clients when I'm working with them in divorces is that judges in divorce court have a lot of latitude. There are laws that give them certain guideposts that they must follow, but there's a lot of issues where they can deviate if you make a proper argument. But as you were talking, it occurred to me that there is one way that a couple who is going to get married after a cohabitation period could protect themselves and make things turn out exactly as they want if they ever get divorced. What is that, Tyler Summers?
That would be what we call a prenuptial agreement.
That's right. And if you're already married, you could still also protect yourself and go into a
post-nuptial agreement.
Right. I'm a huge advocate of prenuptial agreements for anyone getting married, whether you think you make enough or don't make enough, have assets, don't have assets. Really, I tell people that it's your roadmap for navigating a divorce if you ever have one. And it's great to come to terms on these things while you're all still getting along. Do you think that that a prenup or a postnup can be as effective in gay marriage as it can be in heterosexual marriage?
Both prenups and postnups are an incredibly useful tool to guide you in the event your marriage doesn't work out. Now, I get it. No one wants to have these conversations. No one wants to contemplate a divorce in the future, especially when you're engaged and happy, probably your happiest. This is not something people want to discuss. But as you said, roadmap, guidance, having this tool in place, if God forbid something goes wrong, it's going to benefit both spouses. I call a prenup and a postnup, I call them an insurance policy. We don't think twice about having car insurance, about having homeowners insurance. Some of us even have insurance for our iPhone. Why don't we have marriage insurance?
Well, I think that prenups get a bad rap, and there is this perception out there that someone is being taken advantage of in the process. And it's not supposed to be that way. It is to protect both parties. I think typically, if we're thinking about a man and woman getting married, traditional gender roles, the man makes more, has more, the woman is probably more likely to be a stay-at-home parent. And so the prenup is necessary so he can protect his money from her. But realistically, a prenup would protect her as well so that she knows, hey, if I give up my career to be a stay-at-home mom, I know that if we ever got divorced, this is how things are going to be sorted out financially for us, and I'm not going to be left homeless.
The key to enforceable prenups and postnups, Tracy, is both fiancés having independent legal representation. That is how you level the playing field. And with regard to stay-at-home moms, Tracy, I can't tell you how many female clients I have and I've had who are in their early or mid-20s and they're presented with prenups that say no alimony, no division of marital property, no nothing, frankly. And I'll say to them, you're the woman, you may have a child, you may step away from the workforce. What happens to you then? And the initial reaction, Tracy, almost 100% of the time is, oh, I'll never leave the workforce. I'll never do anything more than maternity leave. And when you're 23, that may sound realistic, but things can change drastically once you get into your 30s or 40s.
Yeah, it's, the financial impacts of leaving your career can stretch for years, for decades. If you give up your job to stay home with children, you may never recover those earnings. You may never get back to the level of a career you would have been at otherwise. And so it's so important to think this all the way through. So let me ask you a little bit about spousal support, because I always tell people the spousal support laws are gender neutral. It's really just a formula in each state that generally takes into account how long you were married, how much you're each capable of earning, what you each contributed to the family, etc. And then spousal support is awarded regardless of whether a man or a woman is seeking it. Is it the same way in same-sex marriages? Really just, a formula that's just applied?
Here in Massachusetts, our alimony and spousal support laws, they're gender neutral. I presume that's the case in a majority of the United States. So it's of no relevance whether we're dealing with two men and one of the men will be the recipient of alimony. We're dealing with two women. No impact. Where there is an impact, Tracy, is a sense on the part of same-sex spouses that they may not be treated respectfully or fairly by a family court judge. There's a concern that family court judges may be biased against same-sex couples. And I've often heard, I've had same-sex clients over the years who are the dependent spouse, the one seeking alimony. Well, number one, I'd say men are often embarrassed about having a conversation about receiving alimony. A man should be able to take care of himself. A man shouldn't be dependent on an ex-spouse. We need to change that mindset. If we're dealing with two men and one took a back seat to, let's say, care for children while the other advanced his career, there's no reason why there shouldn't be some amount of alimony.
I see the same kind of issues that you're talking about. I see, particularly for men, that there is a concern that a judge will feel like you're a man, you should be able to go to work, and might not award spousal support, even if it is really something that should be awarded under the law. So definitely, I think an issue that I see as well. Well, as we're talking about stay-at-home parents and things like that, let's talk about the children, because both parents in a same-sex marriage can't be biologically related to their children. So I want to know if a non-biological parent is still going to have rights when they're going through a divorce.
So this is a relatively novel area of the law. And as your viewers and your listeners know, every state in the United States has its own unique divorce, marriage, child custody laws. Here in Massachusetts, we have something what's called de facto parentage. Well, what does that mean? That means if we have same-sex parents, one parent is a biological parent. As you said, in a same-sex situation, we cannot have two biological parents of the same child. But we have two active, involved, loving parents, just one that is biological. And perhaps the non-biological parent isn't on the birth certificate. So what happens when there's a divorce? Does the parent who's non-biological and perhaps not on the birth certificate, does that parent have any rights? Prior to a few years ago, Tracy, here in Massachusetts, the answer was generally no. This could have been a person that was the primary caretaker in this child's life for years, and all of a sudden that could get taken away. Well, we fixed that here in Massachusetts, and now non-biological and non-legal parents do have claims that can be made. And really, this is what's best for the kids.
Right.
And it's not about what's best for the dad or the mom or the other mom. If a stable parental figure has been in a child's life for a lengthy period of time, why would we take that away?
Right. I've unfortunately seen it in these divorces where the biological parent has said, ha ha ha, you are not biologically related to the child and I'm going to withhold. Now, I understand that one of the ways, if someone is in a state that doesn't have the laws as they are in Massachusetts, they could consider adopting that non-biological child, and that may give them greater rights in the event of a divorce someday, correct?
Correct.
Okay, so that's one way.
I think adoption is wise on the part of the non-biological parent.
Is it possible to put some sort of contract in place in case they ever divorce regarding the children and custody?
So yes and no. Contracts regarding children, Tracy, are always modifiable. They're never set in stone. Really, when we're addressing a care and custody issue, we have to look at the circumstances that exist at the time of determination, not the circumstances that may have existed when the two parents signed, let's say, a parenting agreement 4 years before. A lot can change in those 4 years. But certainly, I think there's value in memorializing these understandings and having some sort of documentary evidence if there's a dispute in the future.
Well, and the child custody issues then also affect child support. I mean, I've seen situations where the non-biological parent says, I don't have to pay child support because this isn't my biological child, right?
Yes, I have a case where that is the issue right now. This is a man that is the sole breadwinner. It's a same-sex gay marriage. We have the dependent spouse who is the biological parent, and the breadwinning spouse who's been a loving dad for many years, but now that there's a divorce, his argument is he has no legal responsibilities to these children.
That's sad.
It is very sad, and we'll see what the court does with this.
So there are obviously a lot of interesting legal issues, but I want to talk about a non-technical part of gay divorce with you, and that is losing your chosen family along with your spouse, because LGBT couples often rely on close communities for support because they may not have support from their biological families. And so when they get divorced, it gets really complicated because shared friend groups have to pick sides and things like that. What are your thoughts on that issue?
Sure. So this is an issue that many divorcing couples face, whether they're heterosexual or not. Which friend group is going to side with which spouse? Which family is going to side with each spouse? Now, in the LGBT community, oftentimes family has shunned these people. The biological family, they're gone. They're not interested. They have no involvement. So you have a chosen family, your neighbors, your friends, your colleagues. So while this issue hits both the heterosexual couples and the gay couples, I think it hits harder for gays and lesbians because they may not have that birth family, that biological family to go back to. They may have to build an entirely new chosen family.
So many interesting issues to talk about, Tyler. Thank you so much for being here with me today. I really appreciate you being willing to have this conversation with me. I think it's an important conversation to have. And for people in our audience who are gay or lesbian, they maybe know a lot about a lot of these issues, but nonetheless, still great to get some visibility and understand the concepts. So if someone is looking for a Boston family lawyer for a prenup or a divorce, where are they going to find you, Tyler Summers?
Sure. Well, it's been a pleasure to be with you, Tracy. In terms of where I am, I'm Boston-based. My firm represents individuals, families throughout Massachusetts. We do hundreds of prenups every year. We litigate and mediate divorces. We modify, we enforce divorces. So if you're in this area, reach out. We'd love to help. If you're not in this area, I still want to speak with you. I'm all over social media, TikTok, Instagram, Facebook, at Boston Family Lawyer. I post content quite a bit, informative things, very technical side, but also some lighter topics as well. So I'd love to see you on social media. Shoot me a direct message, comment, and happy to engage.
Yes, Tyler's got a huge following on social media because he's so fun to watch. Thanks again for being here with me today. Great talking to you, Tyler.
Thanks, Tracy. You take care.